Hello, my name is Wesley Alexander, or Joe Alexander, and I'm representing Team 7 today in this presentation. This is a presentation over our case brief, which covers the case Tarasoff v. Regents of the University of California. And without further ado, let's move forward. Beginning with our statement of facts, of course, we have two sides, the plaintiff and the defendants. The plaintiff is actually made up of the parents of victim Tatiana Tarasoff. Now, Tarasoff was the girlfriend of Prosenjant Potter, the patient of Dr. Moore, who is a therapist. Now, Tarasoff was murdered by Prosenjant Potter shortly after returning from a trip to Brazil. The defendants are made up of the Regents of the University of California, which include Dr. Lawrence Moore, Dr. Harvey Paulson, and officers Atkin, Brownriff, Helen Rand Till, and Police Chief William Bell. Now, Dr. Lawrence Moore, who again is the therapist seeing Prosenjant Potter prior to the murder. Now, Potter informed Dr. Moore of his intent to kill Tarasoff, and although Dr. Moore did attempt to have Potter detained for psychiatric evaluation, he did not inform the victim or relevant parties of Potter's intentions. Dr. Harvey Paulson, who is the supervisor to Dr. Moore, had requested that all information on Potter be destroyed. He made this request after an attempt to detain Potter was made. Officer Atkins, Brownriff, Helen Riff Till, and Police Chief William Bill had knowledge of Prosenjant Potter and his mental state, but chose to release him from custody after he appeared to be in a reasonable state of mind. A little bit of background knowledge here. The case was first brought to the attention of the Alameda County Superior Court. Now, the case was immediately demurred on the basis of Tort Claims Act 1963. Now, the plaintiffs appealed the decision through the California Court of Appeals, and the Court of Appeals upheld the decision of the lower courts. Then the plaintiffs proceeded to take the case to the California Supreme Court. There are two issues here, two things to focus on. First being the duty to detain a dangerous patient, and then the duty to inform on a dangerous patient. Beginning with the duty to detain, plaintiffs state that the defendants failed to bring about Potter's confinement pursuant to the Lederman-Petrus-Short Act. Now, evidence showed that a reasonable attempt to detain had been made, and the courts ruled that the first cause of action be barred based off the principle of governmental immunity, which is the Tort Claims Act. Now, for the duty to inform on a dangerous patient, plaintiffs state that although the victim was not the plaintiff's patient, they still had a duty to inform her of impending danger. It was stated that although Tarasoff did not have a primary relationship with the defendants, the fact she did have a primary relationship with the defendant's patient and should have been informed of his intentions. Now, the court found that due to the special relationship with Tarasoff, Potter, and Dr. Moore, Tarasoff should have been made aware of the situation, thus negating the defense of the Tort Claims Act. In 1974, the Supreme Court California announced its first ruling, known as Tarasoff 1. Tarasoff 1 requires mental health professionals to take part in protecting identifiable victims in an attempt to prevent the risk of bodily harm inflicted by a patient. And then in 1976, the Supreme Court established Tarasoff 2, making it mental health professionals' duty to warn individuals at risk and to exercise reasonable care to protect foreseeable victims. In other words, if I am a therapist and my patient tells me that he is preempting to murder his neighbor, it is my obligation, my responsibility, and my duty to take part in protecting that neighbor and to warn that neighbor. Moving forward. In the plaintiff's first cause of action, failure to detain a dangerous patient, the court stated it is to be barred by the principle of governmental immunity. Now, in the plaintiff's second cause of action, failure to warn on dangerous patient, it was determined by the court to be an exception, in which the therapist's obligation is to protect the patient's privacy unless to avert danger and to protect the welfare of the individual or of the community. The protective privilege ends where the public peril begins. Now, courts took into account the restatement second of torts. A duty of care may arise from two circumstances: a special relation between the actor and the third person, which results in the actor to control the third person, or a special relation between the actor and the other, which gives the right of protection. Now, the Principles of Medical Ethics of the American Medical Association, Section 9, states, a physician may not reveal the confidence entrusted to him in the course of medical attendance, unless he is required by law or it becomes necessary in order to protect the welfare of the individual or his community. Now, this is similar to the Merchant Snap Bank and Trust Corporation of Fargo v. United States, 1967 case. The Veterans Administration was held liable for not disclosing the mental health issues of a patient who later murdered his wife. In the case that revealing the confidence is necessary to protect the welfare of an individual, a physician has a duty to warn the proper authorities. Now, the defendants, Dr. Moore, Paulson, Gold, Yandel, failed to exercise reasonable care through revealing the knowledge of Potter's intent to harm Tatiana. As far as dissenting opinion goes, the authorities' decision to impose the duty to warn rejects the balance received by the Lederman-Petra-Short Act. This is a quote from Clark J. Given the importance of confidentiality to the practice of psychiatry, it becomes clear the duty to warn imposed by the majority will cripple the use and effectiveness of psychiatry. Now, for the concurring opinion, this is a quote from Moss J. Dr. Moore, Paulson, this is not a quote, Dr. Moore, Paulson, Yandel, and Gold did assume that Potter had intent to harm/kill Tatiana, and therefore were neglecting and revealing the threat and danger of Tatiana. And as far as dissenting opinion goes, cannot concur the majority's decision that a physician may be held liable for failing to predict a patient's violent tendencies. Psychiatric predictions are unreliable. If a psychiatrist, predicts violence, then the duty to warn arises. In the case of Tarasoff, Regents of California, the defendants, Dr. Moore, Paulson, Gold, and Yandel, did have knowledge of Potter's intent to harm Tatiana, and therefore should be held accountable. Now, the police officers involved should also be held liable because of the release of Potter without first consulting the expert in the situation, Dr. Moore. And that concludes today's presentation. Thank you.